to the Challa weekly webinar. Today is October 13th. I want to thank all those who are joining us today and welcome anyone who is new to our weekly webinar. Today we'll talk a little bit about some of the travel bans, some recent immigration updates, some predictions on what's going to happen. You know, do I switch back from EB2 to EB3? What is, the expected retrogression going to be like? So let's go ahead and get started. First, let's talk a little bit about the travel restrictions. They're most likely going to be lifted in November for borders with Canada and Mexico, and will fully allow vaccinated individuals to enter the U.S. for non-essential purposes, including visiting friends, family, tourism. Beginning early January of 2022, DHS will require that all inbound foreign travelers crossing the U.S. by land or ferry, port of entries, whether for essential or non-essential reasons, be fully vaccinated and provide related proof of vaccination. This approach will provide ample time for essential workers such as truckers, students, healthcare workers to get vaccinated. The new rules are similar to those announced for air travelers, allowing individuals to enter after showing proof of vaccination. But while air travels will have to show proof of a negative COVID test, visitors crossing by land or ferry will not need to be tested prior to entry. CDC is supposed to expect the announcement for a process for airlines to assist with contact tracing to allow health officials to follow up with travelers to notify if they've been exposed to COVID-19. A list of approved vaccinations will be forthcoming, and consular posts are still backlogged. Remember, from the still from limited services and from the pandemic. So visa appointments are still going to be limited, and you've got to refer back to, waivers if you want to try to get an expeditious appointment. Refugee cap is going to be raised in light of the issues with the Afghan refugees. President Trump reduced the admissions to 15,000 for fiscal year 2021. Which was only raised to 62,500 by President Biden in May. Only 11,411 refugees were admitted in 2021, the lowest in 40 years. The increase is going to be for 125,000. The U.S. District Court declares that the DOS cannot cease processing of visas abroad. The court ruled it's in violation of federal law to refuse visas solely because the president proclaimed an entry ban. Consulates and embassies should not stop visa processing simply because of the entry ban, even though the ban applies to individuals who have been present within the past 14 days in a list of approximately 30 countries. Those travelers will still be able to obtain a visa in their home country and travel elsewhere to a country not on the banned list and quarantine for 2 weeks. Currently, consulates and embassies are not issuing visas unless travelers qualify for the national interest exemption. The decision did not order DOS to immediately adjudicate the delayed cases or issue visas, but notes that temporary bans will be lifted soon. Now, this is a big decision, because remember, this has been used by both administrations to restrict travel. And it's long been held that USCIS cannot, Department of State is not permitted to refuse processing or halt processing of visas because of an entry ban. So this is good. It is a federal district court case. So, in the future, if there are any additional travel bans, it will likely be challenged. It's not really immigration news, but it's always great to celebrate immigration in whatever capacity we can. 3 of the 4 American winners of the 2021 Nobel Prize in Physics, Medicine, and Chemistry were given to immigrants. And that is good because it's part of the news. This is the narrative that we're trying to make sure that everybody understands that, immigrants have been awarded almost 38% of the Nobel Prizes won by Americans in these categories since 2000. Of the winners, one came for work, one came as a student, and the third fled violence in the Middle East. So immigrants enhance the United States, and we're thankful to be a part of the immigration journey. Good news is most of the applications for final action date are being acted on in bulk. Since late July, early 2021, USCIS has ramped up their adjustment of status processing to an average of 7,000 to 8,000 per week. Now, if you remember how we noted what the numbers were before, that's pretty substantial. Previously, Oppenheim of the Visa Bulletin, Charlie, as we also warmly call him, estimated that more than 100,000 employment-based visa numbers would go unused in 2021, but now expects a shortfall to be around 85 to 86,000. Based on the intelligence Charlie is receiving from the USCIS, he expects the USCIS volume processing to remain sustained well beyond September 30th of the current fiscal year. But remember, we talked about how there's an interplay with processing and the Visa Bulletin. The more and the faster the petitions get processed, the more likely that there is going to be a retrogression. It accelerates it because more are being processed. The USCIS has improved reporting systems, yielding improved data in the recent weeks, and he says that he's going to keep talking to the USCIS to reevaluate EB3. As more EB3 cases are finalized, fewer otherwise unused numbers will be left to the, EB2 will be left to the EB3. Otherwise, the unused rest of the world are primarily responsible for, or going to be earmarked for EB2 India, and EB2, which is why EB2 India has been advancing as much as they have. Overseas Post will use more numbers as they return to normal processing. And still, each month, but before determining the final dates, Oppenheim will confer with all the posts and the powers that be to see what needs to be done for the following month. Retrogression could occur as early as November 2020. And he had stated that there was a one-time goal of retrogression that significantly cuts off new applications in hope that there'll be forward movement may be possible if unused numbers are available. There could be, and he understands that there could be legislative action against these numbers, and that we still have Congress trying to work out whatever they're able to work out in terms of coming up with a bill that could fix all the issues that we're looking at. So that's the news for this week. We can get started with Q&A, and I'm going to invite our, hello Shaker, how are you?
Hi.
Our moderator, Shaker Challa,
Good afternoon, how are you all?
To get started with our Q&A.
Yep. Good afternoon, everybody. It's been a while, so I'm glad everybody's, I hope everybody's doing well. And so I don't see any questions yet, but hopefully there will be, let's see what's on the chat.
And I know that there has been some, I was out last week. We were attending an intercity visit to Charlotte to find out best practices that Charlotte is, North Carolina is doing to, revitalize their communities so that we can take part in the discussion and strategies to do the same for our community here in Richmond, Virginia. So sorry that we had to miss that last week, but we expect through the end of the year that there won't be any more, interruptions of our weekly webinar. So, tell your friends, make sure we're going to have links we try to connect with you in many different ways. We try to connect with you either through Facebook, Instagram, Twitter, the like. And the reason why we use those various mechanisms is because there are different ways in which, the messaging gets out. Sometimes all you need is a tweet to tell you about the latest that's happening. Sometimes you need a little more. So if you haven't joined us, please do that. Make sure that you do that, like I said, either through Twitter or Instagram or all of the above. If you have not, please share our webinar with your friends and well-wishers and all the other great people in your life. We would greatly appreciate that. And I'm going to share some links with you right now if I can find. There we are. The webinar, I can get it back up and I can share so that you have links. Whoops. Okay. Share screen. There we go. I have like 100 different things open, which I'm pretty sure I'm going to hear about on how I should not have all those things opened. But I am looking for the PowerPoint so I can share the links. Jake, are we getting any questions right now?
Yeah, we have.
Okay, here we go. Let me share the link. And I'm going to do it in the slideshow. I think I can do it in the slideshow. So guys, the reason why I'm sharing the links is so you can take your phone and hold your camera up to the QR code, and you can join our Telegram group, Challa Law Clarity Forum. And in this group, you can join a community of people who are going through a lot of the immigration issues you're going through. Now, the reason why we created this group is when we were in the midst of the pandemic, and I would join other immigration forums, and I try to answer people's questions. They wouldn't let me. They said, we want payment from the people who are asking the questions, and they didn't want the information to be given out for free. That's not what we're about. We wanted to create a platform where we could interact with you when we can. You have a community that can interact with you. So if you haven't, the link is on the bottom. And I think, Kara, I hope this is the one that you showed me with the short link. If not, she's going to put up a short link on the chat. And like I said, if you are on your computer, just put your camera up and you can link with us that way. The other thing is, if you have friends that want to register for our webinar, here's another link you can share with them. Again, you can take your camera up and get the link on your phone and share it with your friends right now. Or you can copy the link either through this or the one that Kara will be sharing in the chat. Finally, we've got a bunch of information in our YouTube channel. And so the only way you can get notified when we post new material is by subscribing. So please, take a look at our channel. We talk about things like CSPA, how to contact the USCIS. What are the many ways you can do that? There's a lot of great information in there. So again, put your phone up, you get the QR code up, and then you can subscribe, share it with your friends, comment. I love to hear from you. And like I said, I really enjoy connecting with everyone, and hope that you all, connect with us. So I will unshare. Let me see how I can do that. I'm trying to make this bigger. Okay, while I work on that, go ahead, Shaker. You want to start with the...
Yeah. First question is from Suresh Kakalakuntra. When can B1, B2 visitors from India start visiting United States? Is there a specific date from when the travel can take place?
When the...
B1, B2 visitors from
right.
India.
Well, we know that, you know, as I had stated earlier, that if they've already got a visa, remember, the only issue is if you are in one of those 30 countries that have a high rate and you've already got a visa, you can quarantine in a non-high risk country and then come into the United States. Travel restrictions for November will be lifted for the borders. So another option would be flying into either Canada or Mexico and trying to come through those areas. And we have, Kara, if you can share the link on our travel restrictions, you can take a look at that and link on that to get some information for details.
Okay. Next question. Any news on H4 and H4 EAD premium processing?
Not yet. I think right now everyone's really focused on adjustment of status. I mean, I think the number 6,000 to 7,000 per week is a pretty substantial number. The highest I think that was processed last year was third quarter was about 10,000. So this is pretty great. And then here is Kara stating that early November, they're lifting the travel restrictions for everyone who's fully vaccinated. But airlines still may require that, you know, what the airline requires may be a little different than what the US requires. So they still may require a test showing that you tested negative before getting on the flight.
Okay, next question. Do you think EB3 will retrogress beyond January 2013? Any guesstimates?
No, I think November will be telling. I think it's, you know, I had been advising everyone from the very beginning, even my own family members, file EB2 and EB3 if you can. And the reason why you want to file that once the perm is certified is because when you file two petitions, one of the petitions, the I-140 petitions, will have the original perm. So if you file it simultaneously, you can file it premium, and they will adjudicate both the EB2 and EB3. If you decide to do that later, you no longer have the original perm. So when you do decide to, at a later date, file it, you can't do it premium immediately. And it takes about anywhere from 6 to 8 months for the USCIS to get a copy of the perm. So that's issue number one. Issue number two, you know, do I think it'll go beyond 2013? I think there's going to be a substantial retrogression in November, but I don't know if it will reach to the level of 2013.
All right. Next question is, these are all anonymous attendees, so that's why I'm not giving a name. So do all the family-based spillover green cards from last fiscal year get allocated to the most retrogressed country, parentheses, India, question mark. So with respect to available family spillover green cards, Indian-born applicants don't need to be concerned about the rest of the world demand, another question mark. Also, how does the family-based spillover green cards get allocated between EB2 and EB3 India?
Right. So I did a webinar just focused on the allocation. So, and I'm doing this by memory, there's 200 and some odd thousand, I think it's 235, but I may be wrong, is the number that's allocated to family-based. That number hasn't been reached in years, mostly because most of the applications for family-based are immediate relatives, which are not part of the visa cap. So what they do is they take all the numbers of family-based, then they subtract from that number the number of people who are immediate relatives. And so, that is the number that then they have this weird thing in the regulations where there has to be a certain amount that is, I guess, the base. And then, it applies to any employment base that is needed. It is a screwed up process. I don't know why the base number is there. But because of that, we have seen that over the years, there's been about 100,000 of unused. And then now we can tack on another 85,000 this year. The reason why it's allocated to India EB3, or previously it was allocated to India EB3, is because of the vast majority of, the queue of the retrogression. But that may be great for a topic for next week, to revisit this and to assess how this is. And since hopefully we should have the visa bulletin for November by next week, that will be a good topic that we'll address. And I'll have numbers and stats and to help everyone again understand how the interworkings are and why why Congress doesn't understand that we don't need to have a bill to help unused family-based, because there's never been a time where, at least in the past several years, that family-based, has reached its full potential, even pre-pandemic.
All right. Next question is from Kapil Karwankar. Can we file H-1B transfer petition without I-140 approval copy?
Oh, because you want to capture the 3 years. Well, you can get a copy of the I-140 if you've got the receipt number. If your employer won't give it to you, at least use the USCIS website where you can get case status. So do you have the receipt number? If you do, you can do that. And you can try with that and cite to the fact that the employer won't give you a copy.
All right. Next one is from Manish Agarwal. Good morning, Challa ma'am. You guys are doing a great job in helping the community. Really appreciate your efforts. Thank you. My question is regarding the My Medical RFE. I have responded to my medical RFE more than 2 months ago. I wanted to understand if there's any timeline that USCIS have to follow to take action on my case once the RFE response has been sent.
No, it's not typical time, so there's not typical time frames. Usually, you get a response within 30 to 40 days. I would check. We have a YouTube video that actually tells you how to contact the USCIS. And there are multiple ways to do it. Emma is not the only way. So take a look at our YouTube video, and I think they must have posted it in chat, on how you can contact them. And this is your time to, there's nothing wrong with bugging the USCIS. People are afraid that there'll be a negative impact by doing that. No, you have to be your advocate, and it's okay to bug them a little bit.
Okay. Next one is from Amit Pandey. Is Texas Service Center approving regular I-140, not just premium? I have a receipt date of early October, but the case is still pending.
If yours was a downgrade, now remember, Texas Service Center is it's as slow as molasses. It's the slowest of all. So have you tried to upgrade to premium? Because if you filed in October, the USCIS, I'm going to assume that yours was a downgrade and you didn't have the original perm. They should have it now. Now, I've heard stories from our Telegram community that there are people who've had to file a request for premium processing 3, maybe 4 times before it was finally upgraded to premium.
All right. The next one is another anonymous. I am planning to join new company using GCE80 soon and would like to know of things that I need to be worried about other than making sure job description is in the same category and the new company will file 485. My priority date is EB3 November 2014.
Now remember, if your company, I mean, if your I-140 is approved, your 485 has been pending for 180 days, and you are going to work for same or similar employment, you can change employers without having to refile anything. The only thing you'll need is an I-485J. That's it.
All right. Next question is, let's see this.
Are we getting any on YouTube? Hi, YouTube folks.
Yeah, I'm just taking chronologically as per the timestamp. So
Okay.
there is a couple of questions. This next question is from Omayeni Salau. I hope I pronounced it correctly. Hello, please, what's the update on EB5 reauthorization?
Great question.
Very timely question.
Yeah, and if anyone is interested in EB5, this is the time to capitalize on it. Now, we have an EB5 session with, a really seasoned EB5 regional center who are also taking direct EB5 now. A few weeks ago, and I'm sure we'll post a link up so you can take a look at it, because we do talk about what the changes are. Now, remember last year, the USCIS through agency policy increased the threshold, the minimum threshold, from 500,000 to 900,000. They also increased the minimum threshold from $1 million to a higher amount, but everyone is kind of really focused on the 500,000 to 900,000. So you had that. And then what happened was the head of the USCIS he didn't have the authority to, because it didn't follow the line of succession. And there's a federal statute on how agencies can, if a director of an agency leaves, who can be in line to succeed, who has the authority and power to succeed. They did not follow that. So all the orders, not just this one on EB5, was deemed null and void because the agency head at that time did not have the authorization. Now, our current USCIS director, who was, through appointed correctly, sanctioned it. He ratified it. But there was a lawsuit. And then the lawsuit said, guess what? Just because, our current DHS director sanctioned it, it is the fruit of the poisonous tree. So I'm sorry, that regulation is not valid. USCIS has still not changed in its policy manual that the threshold is back to 500. But they did state that they would, as they're recently, I think about over a month ago, in the very last day, filed the appeal of that decision. They had stated that they would take filings for the 500,000 while this is being adjudicated. And when they filed for the appeal, they didn't ask for a stay. So a stay means, okay, we're filing the appeal as a U.S. agency, federal, appellate court, please stop people from filing under the 500,000. They didn't do that. And they did say they would accept it. So you have that. Then the other part of this whole EB5 aspect is there are two types of EB5s. One, which is a permanent EB5 program, which is the direct investment. It's written in legislation. regulation. It is a permanent program. There was another program called the pilot program for regional centers, where you would invest in a regional center, which has already received its certification through a filing they have done with the USCIS on their own, using things like an economic, impact statement and a whole bunch of other stuff. That was deemed to sunset this summer, because Congress did not have its act together on so many different ways. For the first time, because this has happened many times before, they did not extend the Eb5 pilot program, the regional center program. So what do we have now? Right now, we have the 500,000 threshold, and then we have direct investment. So what a lot of regional centers are doing is they're repositioning their structure. And in that video, in that YouTube that Kara has attached, you can hear from one regional center. It's Eb5 in North Carolina, and we've worked on this particular. I'm agnostic to how you want to invest, but we've worked with this center on 2 of their projects, and they're very seasoned. They're great to work with. You don't talk to an agent; you actually get to talk to, one of the developers who has skin in the game. So he wants to see it successful. So you can listen to that webinar to see at least how one Eb5 center is structuring this. But you got to act fast, because there is an appeal process going on in place. And I think the appeal process, this is my own opinion, because DHS could have just issued a new regulation with notice and comment. They didn't do that. And so I think that they appealed this decision to encourage Congress to act. Good luck with that. But nevertheless, there's a time clock running, tick, tick, tick. So if you want to benefit from, utilizing this program, you've got to do it now. If you do, email us at info@challalaw.com, and we will be in touch with any additional questions that you have.
This person, Omayeni Sala, who I was just wondering from which country. If you want to send an email, info@challalaw.com, and talk more about it, be glad to give you a call and update you on other aspects related to the process and specific questions if you have any. And I think there's a link there on the YouTube chat, the Eb5 seminar with Eb5. Eb5 is a regional center in Greensboro, North Carolina. So that's where, we had a seminar almost a month or 2 ago, I think. And the project is the Westin Hotel, Greensboro, North Carolina. That is the project. So great project, guaranteed. Your investment is guaranteed.
No,
so
it's not guaranteed.
Not guaranteed. Let me take it.
Yeah, he can't get, because it has to be at risk in order.
At risk, yeah. It's a great investment. Let me say that. Let me rephrase myself.
Yes,
So,
and
because it's a Westin Hotel.
Any regional, any person that tells you that any investment is guaranteed
is not.
It won't qualify for the Eb5 program. And if they promise you something, I'll give you this, and
nothing is guaranteed.
You have this, it wouldn't qualify for the Eb5 program, because in order for it to be valid, it has to be at risk. Now, at risk can mean many things to many people. So you have to do your due diligence and look at the numbers, look at the history, make sure the project is not a massive $200 million project, because anything can go wrong. How is it progressing? Does whoever's developing this project, are they using all Eb5 funds? Are they investing some money of their own? Because I don't know about you, but I'd feel much more comfortable if somebody had some skin in the game, so that they have a lot to lose if the project is not successful. So you want to look at that, and how it's structured before you make a decision, but due diligence. So what you're saying, what Shaker was trying to say is, it's not that it's guaranteed, but because the people who have structured this have a sound financial background, the risk is the risk to value ratio is favorable.
Yeah, the only thing I want to say is what I was trying to say, but Lakshmi is correct, and I'm going to rescind my statement. Nothing is guaranteed. It can be guaranteed, it has to be at risk as far as Eb5 is concerned. What I was trying to say is, I'm paraphrasing when I said guaranteed, but what I was trying to say is the project that Westin Hotel in Greensboro, obviously flagship hotel of the Marriott, run by a gentleman who has done 3 Eb5 projects before successfully. All Eb5 applications have been approved, I-526, so a great track record. So that's what I was trying to say. So that's what I mean by guaranteed, means like the project is, the regional center and the people of the regional center have good credentials because their projects have been, the applications, the Eb5 applicants who have applied, invested in that ARC5, they've all been approved. So the USCIS knows the good credibility. So that's what I was trying to say. But anyway, sorry to distract.
Right, no, and remember Eb5, first you get a conditional green card. We've already got at least 2 people, 2, maybe 3, that are already in the process of getting their conditions removed. So
yeah, so if any of you want to talk more, give me, send me an email, info@Challa Law, send me your number, and I'll be glad to call. Talk to you in any language that you want me to talk. Just kidding. All right, next one, Raj Reddy. He says, he's asking how to find if the birth certificate intro file has been attached to the pending I-485 application. What would be the next steps that USCIS would be working on after issuing an I-485J receipt notice?
Okay, anytime you want to find out the status of, if you responded to an RFE, where your petition is, there is the webinar that we referenced previously that is in the chat. That'll tell you not only how to do it, but what you need, what information you're trying to convey, the phone numbers, the email addresses, the mechanisms that you have. So I would do that and be your adjustment of status self-advocate.
Next one is from Om Adhikari. If you're not vaccinated against COVID-19, are we allowed to travel to US from India or Nepal? Please advise.
No, I don't believe. I think before, and Kara can correct me, if you're not fully vaccinated, then I think you have a visa or your visa exempt, you have to go to that third country. If you're from a country that is not on the list, then I think it's fine. And I think the airline will want to test a negative test before you enter.
They need a 48 hours negative
Right.
test before the flight.
If you are from one of those countries where there's a high incidence of COVID, you have to go to stay in a country that is not on that list for 2 weeks prior to entering the United States.
So here's a message from the office here. There have been a lot of inquiries on H-2B program. So our office here is initiating, PWDs, the cases for filing on January 1st to start working from April 1st. So the request is for you to, talk a little bit about this H-2B program.
Right. H-2B is a program where you bring in seasonal workers. You have to file a prevailing wage, and it's kind of a hybrid of what we do for the perm process versus what we do for the H-1B. But what's great is their quota is 2 times per year, and one is starting in November timeframe. The other is in April. So the employer has to show that there is a temporary need. This is great for people not only in hospitality, in landscaping, anywhere where you can show that your need is within a seasonal time. You can file for multiple workers on one, application, and you can substitute workers. It is a wonderful way to really utilize this mechanism that allows for seasonal work. But you got to get started now because the prevailing wage is taking so long.
All right, this next question is from YouTube. Madhavi from YouTube is asking, how long will Democrats hold EB provisions hostage to their pet project, amnesty? Are you willing to concede, at least now, that Biden is not any better than Trump for EB immigration?
Right.
Wow.
No, I mean, okay, fair enough.
Old question.
Please remember that during it is not whether it's a Democrat or a Republican. There have been Republicans that have made great strides in immigration. Reagan, Bush tried. So it's not because I support one party or another. Okay, let me get that straight out there. But for you to think that the Trump administration was just as bad as the Biden administration, you're not keeping in. Now, this whole idea of holding something hostage, I agree. I agree that they need to break up the immigration regulation into various pockets. But remember, during the Trump administration, H-1B denials were at the highest. They said that if you had an approved petition previously, whether it was an L, H, E, that they were no longer going to give deference when they were doing the extension. So people who had had 4 or 5 approved petitions previously were getting denied, and hence all the lawsuits. They were going to impose a public charge rule. They were going to, it was going to get worse. They were going to make sure that the H-1B lottery was selected based on salary, so that, the Googles and the Microsofts of the world would be the ones and Amazon would be taking up all the H-1Bs. They had, I could go on and on, but the restrictions were ridiculous. They wanted to reclassify what a specialty occupation was. They instituted very onerous requirements in terms of contracts, itineraries, when you're placed at a third-party site. They were trying to erode the system piece by piece. I'm not saying that Biden is a saving grace. I don't think anyone has gotten immigration really right, because the people that are writing the bill and the people that are pushing it don't understand what's happening on ground. So to that extent, I truly understand what you're saying. It doesn't make any sense. And I don't think there has to be an either or, right? I don't think we have to either go with amnesty or either, try to restructure our broken employment-based process. We are now at an all-time high of employers not having enough resources to get the work done, whether it's trucking, whether it's infrastructure, whether it's, God knows, however. And the economy, it's not whether you're a Democrat or Republican, whether you don't even like immigration. If you want the GDP to grow, if you want salaries to get raised, if you want our economy to get better, we have to come up with a more sensible, reasonable business immigration policy that aligns with not only who we are as a nation, but also aligns with, our current economic need.
All right. Well, good one. Karwankar is back saying, what is the current time period for perm approval for H-1B non-immigrant worker? H-1B non-immigrant.
So you're talking about it, because if you're filing an H-1B, it's the LCA, labor condition application. There's no perm for an H-1B. So let me answer both. For an LCA, the LCA can be anywhere from a labor condition application, which is filed with an H-1B petition, can be anywhere from 7 days for companies who have already filed before to 10 days for companies who are filing it for the first time. As far as perms go, I think the processing time for perms is about 9 months, but what's holding everything up is the prevailing wage, which is taking, I think, anywhere from 9 to 12 weeks.
Next question from an AA. My child is getting 21 years of age and will age out in January 2022. I-485 is in process, is in progress. H-4 extension outcome awaited. 17 days adjustment for I-140, priority date October 2014. Is child be out of status when child is 21 years? Question mark. In this situation, is there any way to stay in country and apply for a student visa?
Right. There are a couple of things you can do. I'm going to assume that you filed, that your final action dates were never, your priority date never met final action dates. Because if your priority date had become current at any point, that locks in your child's age. Dates of filings don't lock in the child's age. They're eligible to file, but if they age out, they're out of luck. Whereas if your priority date at any time had been current, then even if there's a retrogression, the child's age is preserved for purposes of AOS. So yes, you can either file, for a change of status to F1. You can, if you think your numbers are going to retrogress, you can file an Eb5 right now for the entire family. And as long as you file before the child turns 21, the time period that the Eb5 will be pending will lock in the child's age. And, then later you can have another adjustment based on the child, or you can file an Eb5 directly for the child. Because if you file an F1 for the child, it's still going to be a challenging process for them. And I feel for you. This is the separation cases that people don't talk about. The child separation in the business immigration realm that is never spoken about. So yes, those are some of the options that you can have for your child if they age out.
Next question, looking at concurrent processing delays at TSC, do you think for a fresh green card candidate should first file I-140 in premium and then file 485 if his date is current, or concurrent filing be faster or will be faster?
Yeah, you can do a concurrent filing and then always upgrade your I-140 to premium at a later date, especially if you have your perm with you. That's a mechanism you can use. It just depends on how strong your I-140 is. If you think that there's going to be an RFE, or it's going to, because you want to make sure you file it within that window. If it's an October 1st, I don't know whether, because we don't have the November numbers yet. So if it's an October 1st, it's already the 11th. 15 days, 15 business days, you'd be cutting it close. So I'd file both and then upgrade at a later time.
All right, next one. Those who have EAD based on I-485, can we work on multiple assignments with different customers?
Yes, when you're talking about working for different, when you say customers, are they your clients or are they your employer's clients? The only thing with the EAD is, one, there's the issue of your H-1B status. So if you have an H-1B and you have an EAD pursuant to your adjustment of status. Yes, you have the ability to work on both. However, if you work for an employer other than your H-1B employer on the EAD, then your H-1B is no longer valid. The other thing is, remember the whole idea of portability. If you're going to work for somebody other than the employer that sponsored your adjustment of status, the I-140 should be approved and the 485 should be pending for 180 days, and you should work for same or similar employment.
All right. Next question. Good morning, Lakshmi ji. Quick question. When can we expect 485 approval after the issuance of I-485J receipt if all the documents were filed with initial petition?
All the documents, did he say?
Yeah.
Well, they're working on them fast. Like I said, they're doing 6,000 to 7,000 per week. So hopefully, if yours was filed and the I-140 has already been approved, you will hear something soon.
Next question from YouTube. Will change of address after getting EAD and before getting green card will change my service center if I move from Nebraska to Texas state, but working with same employer? Yes,
because at some point, they will transfer the file. So you can look at, about a 3-month delay.
Next question. I have an approved EB2 I-140 from my current employer. If I need to file an EB3 I-140, does it need to be done by my current employer or can it be done by an outside attorney? Will it impact any H-1 extensions with the employer?
Well, I-140s are employment-based petitions. So the employer has to be involved. You can't, if you're trying to leverage that same perm, it has to be with the same employer. If you're having another employer who, for prospective work, so you're not working for that employer now, but you plan to work for them in sometime in the future, you have the present intent to work for them sometime in the future, then they can file for you, but they'll have to refile the perm.
All right. This person from Omayeni Salawu says, I'm sorry, my question wasn't answered. I thought we answered, but she's got a follow-up to say I'm sorry, I don't know if she or he, but the person is from Nigeria. And the question is, I just want to know if the Congress is working on reauthorizing the program soon. I am an investor. I thought we talked about it, but maybe you want to clarify.
The program is still running, sir or madam. You can do direct investment now. You don't have to wait for the reauthorization. Email us and we'll have a talk with you and I'll explain that. The Eb5 program for direct investment is live and kicking. So you don't have to wait for Congress's reauthorization. And you can, at this point, try to benefit from the 500,000 threshold, but you have to act fast. So you don't have to wait for reauthorization, so email us and I will explain.
Yep. This next question is from Anil Kumar. Hi, madam, just a quick question. If the EB2 to EB3 downgrades I-140 is denied, then the existing EB2 I-140 also becomes void or denied altogether?
It depends on whether you filed if you filed amended or whether you filed a new. If you filed a new petition, no, that won't impact your existing approved I-140, as long as the denial was not based on fraud or misrepresentation of the underlying firm.
This question is from the chat. Not sure. Just a quick question. If the EB2 to EB3, I think it's the same one. That's it. I don't have any more questions.
And we are finishing on time. Join us next week. I will debunk the whole issues regarding, priority dates and processing time, and we'll know what the November numbers are, and can start talking about strategies as to what to do if you don't have an EB2 petition right now, and you downgraded last year to EB3, or you filed EB3 thinking that EB3 would move faster. What are some strategies? We enjoy coming in. Thank you for taking time out to join us every week. And if you have any additional questions, email us at info@challalaw.com. And don't forget to subscribe to our YouTube video, join us on Telegram. I am not going to be traveling anymore, so I look forward to connecting with all of you. Want to thank Kara, give Kara a big shout out. She is getting ready to celebrate her 10th anniversary. So, and even though I told her, please don't come into the office today, she came in anyway, because that's how dedicated she is to making sure you get to serving all of you. So happy anniversary to Kara and her wonderful husband and their 10 years of marriage. I want to thank Shaker Challa for joining in, and next week, till then, thank you again. Goodbye.
Good night. Have a good week.
You too.
Bye.